Kia ora tātou. Welcome to this week's lecture that I've pre-recorded for you for Tuesday. So we will start with our karakia. Whakataka te hau ki te uru, whakataka te hau ki te tonga. Kia mā kina ki uta, kia mā taratara ki tai, kia hi aki ana te ātākura, he tio, he huka, he hauhu, ti hei mauri ora. And I hope that the weather is well wherever you are in the country and in the world. So a quick recap of last week's lecture. We looked at the treaty in the courts, and so we looked at a number of particular court cases, which some of these will be in the online test. For example, we had the Crown versus Simmons, and we looked at the issues over the preemption waiver and the bringing of Governor Gray to the courts, the issue so that the treaty could be identified in legislation. And the result of this particular court case was that the governor could not waive preemption as agreed to in the treaty, and that the treaty is binding. We then went to 30 years later, Parata versus the Bishop of Wellington, and we find there a subsequent finding, actually a foundational finding from Judge Pendergrast, who identified that the treaty is a simple nullity and it has no legal significance. And we remember that this particular court finding set a precedence for many decades following this court case. And it reflected as well the mentality or particular perspective of our growing settler population in Aotearoa, New Zealand. 1938, Te Hiuhiu Tūkino v Aotea District Māori Land Court, and remembering that this was over some issues around forestry, and the result was that the appeal court found that the treaty is enforceable only when it is included in law. So another foundational move with regards to the treaty in the court systems. In 1987, Huakina Development Trust v Waikato Valley Authority, and we looked at how the court case was actually about how there were particular impacts on the Waikato River, and they were contested by local Māori. And the finding and result that set a precedence in the courts was that the treaty is a part of the fabric of New Zealand society, and could be used as an aid to interpret legislation. And we find that this also revived another foundation identifying that the treaty needed to be included in considerations of the law. Um, 1987, New Zealand Māori Council v Attorney General, and we found that there were issues about lands being returned to Māori when it was, particularly if they were subject to a Waitangi Tribunal claim. And the finding was that the principles of the treaty should take priority, such as good faith, and that there be a memorandum placed on lands, but also that the tribunal should have increased powers. A couple of years later, the court case Tainui Māori Trust Board v Attorney General and others was in regard to mining rights and Coal Corp, and this idea that privatisation would alienate resources for future settlements. The result was that the transfer of mines would require a protection of Māori interests, and referred back to this principle that they should have to apply to give fair results, right? So The government would make the final decisions on treaty issues, and therefore the treaty needed to be applied across court cases. In 1996, we find the Court of Appeal for the urban Māori fishing rights. And it really was a question about how should the fisheries settlement monies be distributed. And the finding was that the treaty provisions should include all Māori, and all Māori must benefit from the outcomes. A couple of years later, we get the Ngāti v Marlborough District Council, and this was a question over whether or not the Māori Land Court could investigate any title to the foreshore and seabed. The result was that the treaty would be confirmed in common law rights, and that claimants could go to the Māori Land Court. And of course, this resulted in the establishment of the Foreshore and Seabed Act in 2004. So that's a recap of Lecture 8, which you'll find is put up here separately.